Welcome to the Greater Zion Law Podcast.
Welcome to the Greater Zion Law Podcast with attorney Travis R. Christiansen. Travis is a Southern Utah attorney who helps individuals and families protect what they've built through practical estate planning, designed to avoid confusion, conflict, and unnecessary legal problems down the road. I'm Lisa Mosby, and today we're talking about estate planning for people moving to Utah.
Hey, just so glad to be here. It's a beautiful day in southern Utah. Most days are beautiful around here, but it's just a beautiful day. So glad to be here.
And I love hiking that area. It's beautiful. You're right. We're talking about estate planning today, and what estate planning issues tend to surprise people after moving to Utah from another state.
I think this is actually one that cuts both ways. I think people are surprised at things that they don't need to change, and I think they're surprised at things that they probably should change. And it might be somewhat unexpected, I think, because the documents that most need changing are typically the more simple documents of an estate plan. And it's not so much that they don't meet legal requirements, it's the familiarity of the people that are going to be viewing those documents that don't have a legal training. The best example of one that most people should change is going to be that it's called different names. Sometimes it's referred to as a living will. Sometimes it's referred to as an advanced directive, providers of, medical care and physicians and all of that. It's that document that, governs your medical treatment. And those are, most states have very strict statutory language that they require for those and a statutorily set up form. And if you bring your form from New York, California, wherever, Idaho, the form may be different than what the nurses and doctors and people at our local hospitals are used to seeing. And so they may not recognize it and they may not honor it simply because it doesn't look familiar to them and they don't have a legal brain. And so that is usually it's a pretty simple document, but that's one that if you move from any state to another state, you really ought to sit down with an estate planning attorney and make sure you update that document at the very least. Because again, it's usually defined clearly in statutes, and it doesn't matter if it's legally effective if the people that are going to be relying on it don't recognize it for what it is because it's different than what they're used to seeing. So that's the one document that I think most people need to make sure they update. A lot of the others may be okay, but you should talk to an attorney. The second one that needs to be updated the most is going to be your power of attorney, your durable power of attorney. Again, this is one that the language is very strictly prescribed by various legislatures very strictly. And if it's one that, again, local banks, local investment guys or whatnot that you might be working with here in southern Utah don't recognize the language, they may not honor it. So the more simple documents of an estate plan tend to be the ones that need updating the most, simply because they're the ones that lay people, if you will, are going to be interacting with the most.
And other pieces of that estate plan are the will and the trust. If you're moving from another state with a will or a trust, what parts of those documents usually still need some work after moving to Utah?
So the most common one we run into here is, and this is kind of a weird one, and it goes back to the history of this country, right? So in some states, we have what are called community property laws. And so those are the states that by default, if you're married, your spouse owns half of everything, whether or not they're on title or not. They automatically own half. And those are typically, there's some states that have adopted it by legislation and some states that have had it by tradition. So if you start in Louisiana, they were originally French, right? French based on that community property thing. In Texas, Arizona, New Mexico, California, Nevada, Oregon, Washington. Are you seeing a pattern here? These are the states who were originally settled by the Spanish, and it's that community property default there. Now, Idaho and Wisconsin, I believe, and maybe a couple others have adopted community property, but it's not their tradition. The states in our country that were settled typically by the English settlers or, Dutch and that kind of stuff, essentially that drew from the original 13 colonies, and imported that common law, those states have this equitable division language where unless you put your spouse on title, they aren't on title. And so when you come from one of those states with community property, you need to have it, in particular, the community property states, you need to have it looked at for a couple of reasons. Number one, there may be triggering language and tests that might not meet Utah law as far as when a successor trustee can take over. There may be issues with distribution post of the first spouse's death because of holdover community property law issues. And it's not so much, again, that it might be ineffective or it may be a perfectly fine trust. But again, it's that user error that you're going to run into because, if I look at in southern Utah, almost all of my judges of the 5 currently sitting, 4 of those 5 were in government work. They were prosecutors, worked for Utah Attorney General's office. Estate planning and some of the complexities and nuance isn't their forte. And so sometimes just for user ease, getting it to one of my local judges, if we have to litigate it, if it references Utah law that they've gained some familiarity with after being on the bench, even though they never did it, it's going to be easier for them to digest and deal with and litigate than if we're saying, hey, this is relying on Louisiana code section such and such. And now they got to go look it up. They got to check the case law. They're going to want me or whoever you've got maybe litigating that, looking those things up and trying to sort, what does this mean in Louisiana? I mean, that can be a question and it's hard. Now, most commonly we're dealing with California, Nevada, Arizona, because we're right down here in the southern corner, southwest corner of Utah, where we border those areas closely. And so we deal with more interstate travel there. But again, the trust may be great, but it's those community property holdover, some of that language we have to deal with often. And again, sometimes making sure we just change it so that if we are in court, that the guys and gals that are making decisions for us are familiar with the language and the provisions and the law that governs those things so that we don't have to spend a lot of money in attorney's fees educating them. Yeah, but in Arizona, it means this. Well, Utah, it means this. No, Arizona, it means this. This is what we meant. Let's make sure it's what you mean in the state. You may have to adjudicate it, or your kids or family might have to have an adjudicated decision made about it. So that's one of the other things. Again, the will is probably the least one that needs to be amended because most states have really adopted a uniform process. Wills can fall apart if they aren't witnessed correctly. That's the most common mistake in a will, but if they've been done by an attorney, they're going to have those self-proving affidavits and the witnesses and the things that'll make it valid. And it's just going to, again, in an estate plan, most wills pour over into a trust. And so that's, the trust we may have to do with those nuances between state law, but the will is probably the least one that we might need to change. Just based on a move. There may be other reasons, but based on a move, that's the least common one we would probably have to do much with.
The moral of the story is just have it looked at because there are some nuances that need to be taken care of when you cross a state border in the United States, right?
Yeah. And it's because we have different laws in different states, and that's part of the great experiment of America, right? I mean, we create different laws in different states, and that really works well in one state, and another state says, hey, I think we want to try that. I mean, it's not related to estate planning, but a great example of where law in one state filters over to others just for fun is stalking, where somebody, following you and taking pictures and bothering you. Well, that originally starts in California, right? With the paparazzi and the movie stars and the celebrities. Well, now pretty much every state has adopted that to meet the needs of their state because of what started in California. So it's a great example of where, but that's part of the genius, frankly, of America. And that's been on my mind a lot. We're recording this really close to the 4th of July. It might pop sometime after. And so thinking about the greatness of America. And that's one of the cool things is the experimenting that we do in this country with different laws in different states then benefit all the other states because we have that federalism and the ability to experiment and do different things. Sorry for the tangent, but it's just interesting to me how some of that works.
Travis, I have to say it's never a tangent with you. I think the thing that I find most unique about you and the thing that I most enjoy about conversations with you is your ability to bring in history. I did not know about how the laws were based on history, like Louisiana and those folks, the Spaniards. Like it's always so fascinating because you have such a way of making the law interesting and estate planning interesting and specific. What Utah specific laws or planning issues do people most commonly overlook after becoming a Utah resident?
Well, there's a couple. And this is where, again, that
Yeah.
federalism idea comes into play, because Utah has done some really interesting and, frankly, leading edge drafting. And some of this hasn't been tested in the court, so it's kind of a wait and see. But Utah has done a couple of things that are really, I mean, if you can use the word sexy about estate planning, it is to me. Um, One is we've created an asset protection trust that if you do it right, and after either 4 months or a year, whatever assets are put into this trust are forever barred from creditors. The IRS might be the only exception, but you can create a trust in Utah under Utah law that a creditor can't touch no matter what. And you can put all kinds of stuff. This is a great planning tool, and we can get into detail maybe in another episode, but it's one of those
Sure.
things that Utah is doing to lead the country in some ways in estate planning. And the other one is really interesting. It's called a legacy or dynasty trust. So in the law, there's this archaic concept called the rule against perpetuities. And it takes like 3 weeks of law school to start figuring out this weird law from the Middle Ages in England. And it's the legal definition is it's a life in being plus 21 years, right? So, but what in the world does that mean, Lisa? No, I mean, yeah, you're
I
like,
don't know.
holy cow. So, but it typically means that, if I create a trust, it can only last 21 years past the death of like the youngest member of my family still alive. Um, an interesting example of this rule against perpetuities thing that came up is when Walt Disney and his brother were building Disney World down in Florida with some of the really, I don't know how they did it, but they had some really cool legal carve outs that said these things will last until the youngest of the then living descendants of Queen Elizabeth II dies. So that was honoring the rule against perpetuities, but they wanted to define it by somebody everybody knew. And so whoever it was, when they signed these things, when that person dies, those legal protections for Disney World go away. And it's a way to help work within the rule against perpetuity. So you couldn't have an interest in property that lasted or violated that rule against perpetuities. It was longer than that. And so Utah said, well, that's poppycock, right? I mean, that's an old English law that we adopted and we've just been living with. So Utah created a trust, get this, that can last 1,000 years, called a legacy trust. And so one example that's really famous here in Utah is Larry H. Miller and his wife Gail. They were the owners of the Utah Jazz, and then he passed, and then they recently sold part of it. They put the Jazz, and they put the Delta Center, or it's had a couple of different names, but the arena downtown Salt Lake City where they play and some of the other assets around that sporting thing that they had in Utah into this legacy trust. And some of the rules were that those things could never be sold outside of the state of Utah, that you couldn't transfer the franchise, and some of those things using a legacy trust. So they locked it in. Now, since then, the family has sold the rights of that trust, but the new buyers are bound by the terms of the trust because they created this legacy trust. So it's just one of those other things that you have in Utah, and some other states have started to copy it, that your family, if you've moved here, could benefit from, right? Because maybe you've got some old, the old family farm, wherever it is. It should be a museum because of the history and who your ancestors were or something. And it's going to get sold off and torn down and whatever. You can do those kind of things using a Utah trust. So, and that legacy trust, and also we're leading the edge on asset protection trust.
Travis, how do beneficiary designations, property titles, and multi state real estate ownership create complications in estate planning?
Again, it's sometimes when you're crossing between a common law property state and a community property state where you've got to make sure deeds are possibly amended. You've got to make sure, again, I'm on a border state. I just today, before I started my podcast, we had a client in here that was dealing with amendments to her trust, dealing with property in Arizona. And when I have that, I bring in some of my Arizona colleagues and friends to make sure the deed and some of those are recorded right as far as the trust goes. If you're transferring, one of the interesting things is with community property, very often if you're doing a transfer of your property that's only been in your name into a trust, even though your spouse is an untitled, they have to sign as the spouse saying they're okay with the transfer because it's changing the community property characteristics of that asset. So when we're looking with these different states, I've got colleagues and friends in almost every state in the country, or people I can reach out to and say, hey, I've got this person, they now live in Utah, they moved here from Arizona, and this is what we're doing. What do you recommend we do to make sure the title remains as it is or fixes it or whatever? Because I know I don't know everything. And so I'm going to reach out to my buddies that know what I need to know in those other states to make sure we do it right. But the most common is, yeah, you've got that community property versus common law property issue that you've got to handle and make sure your deed work is done right and some of those kind of things so that the property is actually in the trust that you want it to be in, because if you don't do that transfer with and get that spousal sign off or other sign offs that you need to do. The other thing that can be interesting with beneficiary designations is you need to kind of watch for, depending on the size of your estate, is that some states will have an inheritance tax. And so if you've got a child or a beneficiary that lives in a certain state that still has an inheritance tax, you might want to check and make sure that how the property gets distributed to them is done in a way to maybe minimize those taxes or legally avoid them altogether. Now, you don't evade taxes, that's illegal, but tax avoidance is perfectly fine, and we do that. And so we want to, that can be a wrinkle when you've got beneficiaries that live around the country is, hey, all of a sudden they inherit $1 million from mom and dad and they got to give 30% of it to their state because they hit these benchmarks in that particular state's inheritance tax.
There's one other that I want to ask you about today, and that's the healthcare directives. Sometimes we don't think about that when we change states, but again, another one that has significant differences depending on where you are. Can you speak to that, how it affects people in Utah?
Well, again, as I mentioned when we kind of started, that healthcare directed, living will, advanced directive providers, it's got a bunch of different names in different states. Again, that's one where it's the end user that you need to keep in mind. That might be legally, that document is most likely sufficient that you get in Texas before you moved here. But the issue is if you take that Texas advanced directive or living will or medical power of attorney into our local hospital and that person looks down at it and says, I don't recognize that document, I'm not going to honor that document because it's not what they're trained to recognize and see. So that is probably one of the first most critical things. If you've moved really from any state to any state nationwide, is make sure that that advanced directive, living will, medical power of attorney, whatever it's called there, meets, that you just do a new one that meets that state so that the healthcare providers are going to be looking at it, recognize it as, oh, that's what that is. I know now this person, if they'll show me their ID, can make your decisions for you and take care of those needs. So that's the one I've seen the most problems with. And here's the thing. If you don't do that, here's what happens is if your loved one is incapacitated and even though it's a perfectly legal document, but the hospital won't honor it, and let's face it, whether it's legal or not, it's a hospital that's got to say, yeah, we're okay with that. You can make these decisions. I've had to take grandma or grandpa dying in the hospital, and I've had to take that document from another state, and we've had to file a petition in the Utah courts to appoint a guardian and conservator because it's not that the document wasn't perfectly legal. It was that non-law trained end user didn't recognize the document for what it was worth. So we had to go to court and delay days at best, weeks at worst, or months treatment for somebody because the document hadn't been updated. Now, fortunately, I've got a great relationship with my local judges, and I've been able to get those orders issued on an emergency basis in 48, 72 hours. And then we have to have some follow-up hearings and whatnot, but that's expensive, time-consuming, and frankly unnecessary if you just come and talk to me or one of my colleagues about updating that advanced directive living will, because it's going to keep your family out of court. Because I've had to go to court with families that had a perfectly legal one from another state that the end user didn't recognize what it was, and that's really is the biggest issue with those advanced directives, living wills and whatnot is the end user seeing it for what it is, so that I don't have to go to court, get a court order that they go, oh, this is a court order. We know what this is. Yeah, sure, we can give your dad that life-saving treatment 3 days after he really needed it. When you move, so when you move here, that's the bottom line. I'm just going to give this conclusory comment to all of this discussion if I can. When you move from any state to any state, please, even if they charge you $200, $300, $400, $500, go take your estate planning documents in to a competent estate planning attorney where you moved. If you've moved here, bring it in, let us look at it, and make sure that any small documents are updated. It probably won't require a complete rewrite, but there's some of those little documents that just for end user purposes, we probably need to look at and update so that your life is smooth and easy the way you've spent good money on an estate plan to hopefully make sure that your life and the life of your family is smooth and easy as your life progresses. In, incapacity is very common. And then just when people pass away, so that life is easy as it can be in those circumstances.
And that's it for today's episode of the Greater Zion Law Podcast with Travis R. Christiansen. If you've recently moved to Utah or are planning a move and want to make sure that your estate plan still works the way you intended it, visit greaterzionlaw.com to learn more. Thank you so much for listening, and don't forget to like, subscribe, and leave us a review. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.